Well, if you've never been through a trial, you probably only know what you see on TV or on the big screen. In this week's Know the Law segment, Tom Sinas joining us to talk about the real trial process, Tom.
Boy, it really isn't like what you see on
Right.
TV. And most people, hopefully, will only ever be involved in trial if they are as a juror.
Right, that's always nice.
And so people sort of want to know, well, if that happens to me, what process can I expect?
Sure.
So, well, the first thing that will happen in a trial, if it's a trial by jury, is that the lawyers have to go through a process that we call voir dire, which is a French word for jury selection.
Okay.
Lawyers get a chance to ask a group of jurors a bunch of questions to try to find the right mix of jurors who are going to sit on that trial.
Okay.
Once you have your jury selected, you then begin the process of a trial. Well, what happens first? The first thing that happens in a trial is that each side gives its opening statement.
Sure.
An opening statement is a preview of the evidence that the various sides are going to present. And this happens in both civil and criminal cases.
Okay.
So the prosecution typically will give its opening statement first, and the defense will then give its opening statement after, with each previewing the evidence they're going to present. After you get beyond that, you get to the phase of the trial where the evidence comes in. Well, what's evidence?
Yeah.
Well, evidence is witnesses and the things they say on the witness stand. It's also physical evidence.
Sure.
So in criminal cases, drugs, guns, that's all evidence.
Sure.
All of that comes in during the evidence phase of the case, and it comes in through various witnesses. Once all that's done, you get to the phase of the case called the closing argument. What's a closing argument? Well, the opening statement, remember, was a preview of the evidence that was going to come in. The closing argument is not only a summary of the evidence that came in, but it's the lawyer's opportunity to really argue their view of the case. That's really the chance in the case where they get to try to persuade the jury that their position is the correct one.
Leave a lasting impression, if you will, as they go to deliberate eventually.
That's right. And there's been famous closing arguments over the history of law that people remember and remember for a long time. What happens after closing arguments? Well, then it's the jury's time to deliberate. That is, to decide the case. How do they decide the case? Well, the judge tells them, you have this law, and the judge gives them the law.
Sure.
Gives them what are called jury instructions. Says, this is the law that you have to apply. You've sat through the trial, and you've seen all these facts. Now go as a group and apply the law to the facts and come back with a decision. And in a criminal case, it has to be a unanimous decision. Got to be 12 unanimous jurors. In a civil case, it can be 5 out of 6 jurors. And whatever decision that jury reached, that is the ultimate decision for that particular trial.
We got a couple seconds here. Let's say you get 11 of the 12. Does it automatically become a hung jury, or does it mean, tell me about the differences, not getting everyone to say yes on the 12?
Well, in a criminal case, you have to have a unanimous verdict typically. So if they can't get beyond that one juror who's holding out, then you can have what's called a hung jury, and that can result in a mistrial, and that can result in having to try the case all over again.
Sure.
And then we go through that whole process that we just talked about.
It is fascinating. There are some great movies, some great books about the trial process. If anyone wants to learn more about it, how do they get a hold of you?
They can find us, they can give us a call in Grand Rapids, 616-301-3333. You can find us online at sinasdramis.com or shoot us an email at info@sinasdramis.com.
It is interesting stuff. Thanks, Tom.
Thanks for having me.